Spit it out.
So we didn't like where we
That's unbelievable.
so we don't have line of sight. Good luck is like the sellers have it. So this company here, when it's legal, it doesn't matter what company. So we just, this is
Y'all brought backup, I see. Gentlemen.
Morning, how are you?
because most of them
Got the beat down shirt on today. You're gonna have to take it easy on us tonight.
Oh. What's,
What school your kids go to?
is it the second? Oh, Catholic.
It's a rebuilding here.
That happens.
Apparently Great Crossing's on kind of a roll. They put it to Henry Clay.
Yeah.
And Henry Clay is always good athletically all
Is
around.
it? Are you sure about that?
Yeah.
I watch Henry Clay get smoked all the time. I was like, but okay. I'll take your word for it.
Of course, it's been 20 years since they had all their free athletes. Who was there? Was it Demetrius Green or something?
All I know is Henry Clay's got a very loud band.
Did the Army postpone game last night?
It wasn't planning on being postponed on set tonight or yesterday anyway. They wanted to, when they requested in August, to do August and September's meetings. So they were always planning on going to October for their meetings. They were always planning on it. Which is why I was like, can we not have everybody apply at the same time?
Well, I mean, so that meeting, I mean,
There's 13 items on that agenda right now.
Yeah, we're working on it. We're trying to come up
But
with
it's
some
like
creative
8
solution.
sites, but it's 13 items. Like it's, I mean, it's fine, honestly.
anybody wants to be on the same show.
No, we don't. We're gonna put them at the end,
They might,
probably.
they might want the entertainment. Hit their monies and time's worth, you know.
Yeah. We're working on it. We're not gonna do it here. We're trying to find an alternative location that is going to be larger to fit it because they essentially were like, it's gonna be a lot, and I was like, all right, you know what? You guys are inflating it a little bit, I think, but okay.
That's how it's going to go.
It is gonna be like we're gonna rent Great Crossing and no one's gonna be there.
I always,
It's gonna go in October for sure.
October for sure. If they don't go to October, like if they request another postponement, it's been 3 months, it's a withdrawal, and they have to restart the process again. And I've told them that. I was like, you need to tell me this sooner rather than later because we have to relocate.
to get you one of these at the outlet or something this weekend.
So we'll work on it. I mean, like, we'll manage it, but
We'll get it stitched up for you.
Can't do it yet. Got to get y'all all the way through.
I get you.
I don't know.
I'm going to stay away from my onion
Yeah.
rings, I guess I will too.
Huh?
Things are so good though.
The tots is what I gotta stay away from.
Were you doing pro bono work or were you working
Oh,
with?
no, we were just, you know, I just really don't want to be on the same dock.
Oh, I know. No one wants to.
With Georgetown College, that's a big factor too.
Yeah.
We need to have both of those at the same
Yeah.
time.
And we were supposed to have as well. They were also.
Oh, really?
They've already requested. They were working in
Well, I
they
just
have
talked
something
to.
that they changed in between their filing periods.
So they
Georgetown Commons is the application, marketplace. It is Obama.
Oh, yeah, yeah. She said it's there. He ran it over.
Through the back door.
try to tell her, but Laura doesn't come after 12. But they don't get that's what she said, all that other stuff. They're coming It's hard.
Good morning, everybody. Call our meeting to order. It is 9 a.m. on Friday, September something called 13. No superstition here. It is a business meeting for the Scott County Fiscal Court, and we are glad to have you all here with us. We have quite a bit of business to cover. I would ask you all to join me in the Pledge of Allegiance. Let us pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Ms. Hamilton, will you call the roll, please?
Mr. Hostetler.
Present.
Mr. Jones.
Here.
Mr. Wallace.
Here.
Mr. Corman.
Present.
Mr. Ellison. Mr. Pratt.
Here.
Mr. Livingston. Mr. Culbertson.
Here.
Judge Covington.
Present. With that said, we will consider the minutes from our previous meeting as presented by email from Ms. Hamilton. Are there any questions or comments related to those minutes? Motion from Mr. Pratt, second from Mr. Jones. Any other questions or comments? All those in favor, please say aye. Aye. Any opposed? Motion passes. Bills and hand checks as presented. Any questions or comments related to those? Oh, sorry, I skipped right over transfers. Where's my check mark? Transfers, let's go to transfers. Any questions or comments about the transfers as presented?
Big social services, $750,000.
I have notes, Kelly. Hold on.
Michelle is on an airplane going to help move her daughter. So go.
What's the amount? Kelly?
One towards the bottom.
Federal grant.
So let the record reflect that Mr. Livingston is present.
Federal grants, that might have something to do with the broadband.
Social services.
Oh, I thought you said the federal
No,
grants.
the $750,000. They were handed towards something, one of our projects.
Oh, okay, it's a different federal grant. What's Amen House?
She didn't say anything.
That's what my guesstimate, but I don't.
We
It's
paid
at
the
C-
Amen House this time, so.
It's the CDBG grant for the Amen House. That's what it is.
I'll make a motion.
All right. Would there be a second?
Second.
Second. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. And then we'll go to bills and hand checks. Any questions or comments about that? We are doing a transfer. It's the first draw on the broadband project that Spectrum has gotten. I did want to mention that as well. But that's.
I just saw that starts with an 07, Kelly. It is, that's a
That's what it is.
Yeah. But any questions about the bills and hand checks?
Well, Judge, I was going to ask this at the end, but since we talked about our transfer spectrum, where are we at with, there's two problem areas, and one, I've got a constituent.
On
that's
Tuesday,
concerned.
Jared and I were, and I talked to your constituent, our constituent already. They are working on Craig Lane, according to Spectrum, on Tuesday. Like, I'll call again today and confirm that. But like, the work was scheduled, and they said they had crews scheduled for work
For
Craig Lane.
this coming Tuesday or this week?
This past Tuesday, they said that work was starting.
Okay.
You know, it's been a long process to get all that navigated. But
Yeah, and you're still working with the railroads, I believe, as well.
all the permits for the railroads have been approved except one. And here's the one that goes under double cover, that goes underneath the railroad in the tunnel.
Yeah.
So, to go one more step forward, trying to do everything we can, we have talked with Robert Swanigan, who is with AMK, and they have done projects in Madison County for communication, running fiber for communication between water towers and their 911 system. They are running fiber, a 10-millimeter fiber cable through water lines.
Yeah, wet fiber.
And we have connected AMK with Spectrum, and then I had a phone call with Susan Loncho from Kentucky American yesterday, making an official request from us if they would consider letting AMK and Spectrum do this passage. And from Robert Swanigan's feedback, there's a very close water line that goes right through there, and it would not be a complicated effort. So we're turning every rock over trying to finish this.
Okay, thank you.
Yes, sir. So if not, would there be a motion to accept the bills and hand checks? Motion. Second, David Livingston. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Let the record reflect that the county clerk, Rebecca Johnson, committed and submitted fees in the amount of $217,606.89. Let the record reflect that sheriff's fees, Sheriff Tony Hampton submitted fees in the amount of $50,935.02. With that said, we have a special guest, Deborah Calhoun. Ms. Calhoun, if you would step up to the podium, and you wanted to, on behalf of the chamber, you wanted to recognize how many years of membership from the fiscal court?
20 years and more.
20 years or more. So we're very proud of our relationship with the chamber. We're very appreciative of all the chamber does for our community and our businesses and the connections. It's about relationships.
It is.
And I see it firsthand every day, and really appreciate the work you all do. Appreciate the recognition of the long-term membership. I've seen your all's pictures, and you're all
Yes.
Appreciate that. Would you like to do a picture?
I would
with
love
the
to
court?
do a picture.
All
So
right.
do you all want to come in front, or can
We'll
you all
come
just
in
spin this
front,
back?
and you can join us right there in the
Yeah,
middle.
sure.
And we'll knock this out.
Photoshop would be great.
You'll stand on these stairs if you want to go back there and behind the podium and take a picture.
Yeah.
How about I take it?
Oh, Stacy, you can stand right here in the middle next to Chad and Kelly. I'm sliding in there. I'm sliding in there.
You can edit.
Here, I'm sliding in there.
Okay.
We can pivot. There we go. You're the man again.
Like forever.
Thank you.
You all have an awesome day.
You too. All right, that leads us down to number 8 in our agenda, ordinance 2406, second reading of an amendment to 2310. And I'll ask Mr. Cam Culbertson to read it. Then we'll take any comment. If anyone wants to make any comment, we'll be more than happy to do that before considering the second reading. Any questions before Cam reads that? Thank you.
Scott County Fiscal Court Ordinance Number 24-06, an ordinance amending ordinance number 23-10 pertaining to RV campgrounds. Whereas the Scott County Fiscal Court has enacted ordinance number 23-10, amending the zoning ordinance of Scott County, Kentucky, and the cities of Georgetown, Sadieville, and Stamping Ground, or zoning ordinance pertaining to RV campgrounds. And whereas the summary of ordinance number 23-10 contained provision stating that RV campgrounds shall have a maximum density of 5 RV sites per acre when served by private sewer systems, but this text was inadvertently omitted from the body of the ordinance. Now therefore be it ordained by the Scott County Fiscal Court, 1, Section 2.51D2 of the zoning ordinance is amended as follows. 14, RV campground developments shall have a maximum density of 10 RV sites per gross acre when served by public sanitary sewer, and a maximum density of 5 RV sites per gross acre when served by private sewer systems. 2, effective date. This ordinance shall take effect upon its passage and publication. The first reading was approved August 22nd, 2024. Second reading is today, September 13th, 2024.
Questions or comments? And would there be any questions or comments from anyone in our audience?
Yes, Judge.
Hey, Mr. Murphy, how are you?
Good to see you again. I, along with my wife, own a farm that this ordinance could potentially impact. The farm is located on Muir Lane and also fronts on Midway Road. And that frontage is what actually got me into your business because for whatever reason, a rezoning request for an RV park appeared in front of my property, which is about half a mile away from where the actual rezoning took place. Now, I think I, like a lot of folks, understand zoning to a certain level. A means agricultural, B means business, people are going to sell you something. C is commercial, people are going to build something or services thereof. That's probably about the level of depth that most Scott Countyans dig into this thing. It's not the in-depth detail that I've had to pull myself through to kind of appreciate what you guys have actually done. So I've got some handouts that I would like to provide you that I think will help explain. So let me take just a second to hand these out to you.
Dick, I can do it if you want.
Oh, okay, thanks. Let me take one of them.
These?
Yep, and they're in, these are already collated. So here's one example of what should be.
Okay.
So what is being handed out is kind of my summary of what I'm calling the devolution of this amendment. And let me explain why I use the word devolution. It's primarily because it started out in 2022 by a request, you judge, of the planning and zoning to create an RV ordinance. And I wholeheartedly agree there needs to be an RV ordinance. The one before you, I do not think is the right ordinance, but there needs to be one. And I'll tell you why in just a few minutes why I think this one is not correct. But it started out in July of 2022. So to sort of simplify this, if you would turn to page 1 of this chart. Page 1 shows the beginning, and at that point in time, it had 3 key components in it. Those components included no private sewer systems, 5 acres per RV without public sewer, and prime soil protection. So those are the 3 key points that I'd like you to keep in mind. So the timeline that I've created here is simply on page 1, a replay of all the meetings that have taken place, either planning and zoning and or fiscal court. It highlights the ads that were placed. So that's the basis for my most recent request, Judge, that we talked about earlier this week. It was simple as that. I just wanted to make sure I had all the dates in there.
That I provided.
Yeah. So we're fine there. Now, if you'll flip over to page 2, that's the real heart of what I want to talk about. So we start out in July. Thank you. Oh, no, I meant to keep those, but thank you. So we start out in July with what I call a farm-friendly ordinance. My background is engineering, so I'm visual. I like to measure things and count things. So I've created a scale on the left. I would consider that ordinance that was approved in 2022 to be a 10 on farm friendliness. It says we're going to protect prime soil farmland. We're going to stick to agriculturally accepted standards in this county of 1 residence per 5 acres, and we're not going to have any private sewer systems. That's in 2215, very clearly stated, and stated by then Matt Summers, who was representing the staff of planning and zoning. So those things are in there. So what happens is the ordinance gets passed in that form by planning and zoning. It gets handed over to fiscal court. There is a meeting in August and of that year, and then what happens in that meeting, and Mr. Wallace brought up some good points, Mr. Livingston brought up some excellent points, Mr. Hostetler brought up some points, and I think Mr. Pratt also commented at that point in time. And it all centered around how many entrances should it have. That was the bulk of it. But the topic of public sewers also came up at that point, and Mr. Wallace raised that one. So there's a lot of discussion. You kind of discouraged a motion at that point in time, which was understandable because there was so much discussion. The suggestion was, let's just table it until we're actually ready for a motion. And then it moved on. It moved on, and there was in November of 2022, I'm sorry I skipped ahead there for just a minute. Let's go back to 2022 because this is where the really strange thing happens. Is in November of 2022, there was a reading of what was then called the 2215 amendment, first reading. There was an ad that came out that said there's going to be a second reading, and it's going to be November 12th, 2022. 22nd, I'm sorry, 2022. That never happened. It never took place. There's no documentation that says why it never took place. There's no documentation that says we're going to kick this back to planning and zoning. There's no documentation that says why it was kicked back to planning and zoning. It just happened. So on my chart, I refer to that as behind-the-scenes discussions because there is evidence in the open records that there was a lot of dialogue going on about things that needed to be changed. But none of that was happening in the public. It was just background noise. So finally in February, So now I am back into 2023. February, a new form of what I consider to be 2215 appears. And that form now says no private sewer systems is still in there, no prime soil protection still in there, 1.75 acres without public sewer. So all of a sudden, the density has gone up. Mr. Summers defends that position by saying that's consistent with our current cluster subdivision density, which I'm thinking, I don't like it, but I guess that's reasonable. And so that was his position, and he very firmly stated, I don't plan to make any more changes. But what happens when they present that in February, Mr. Hopewell, who owns property and has a vested interest in what this ordinance looks like, says, I haven't had time to read this. I'd like to have time to read it. Planning and Zoning chooses to table it because one person, a developer, says, I've not had time to look at it. We'll take it up the next meeting. It didn't get taken up the next meeting. Don't know why, no reason given, but March it didn't get taken up. Now look at April 13th. What happens is there's a sales pitch by the other Dick Murphy, coincidentally the lawyer for KBER, Kentucky Bluegrass Experience Resort, who introduces another party with a vested interest, a distributor for a FujiClean system, which is, I refer to it as a packaged sewer treatment plant. And I know you've struggled with what is a packaged sewer treatment plant and what's not a packaged sewer treatment plant. So they listened to a presentation, and we'll come back to that presentation in just a minute, but that happened in April. Also in that meeting, Mr. Hopewell made it very clear that this is phase one. These 200 units that we're kind of talking about, that's phase one. We're going to go across the creek, Woodford County, we're going to build out there, and he still has in his head what is still on their website. This is going to be about a 1,000 site RV park when the two are combined, which goes right back, and I think it might have been you, Mr. Corman, who asked the question in one of these discussions, well, what happens if at the time the topic was 200? What happens when 200? How many entrances do we need? And the answer that came back was, and I think you asked, what if 150 of them are in Woodford County and 51 of them are in Scott County? Does that kick into an extra entrance? Because at the time there were 2 required for 200. And the answer was, well, we would definitely have to take that under consideration. So here's one fly in the ointment. What if you reverse that? What if you already got approval for 199 in Scott County and then 200 in Woodford County? You've got no say now on how many they need. It's too late, which was something Mr. Livingston brought up by citing the fact that we've got to be very careful about this ordinance because we have to live with it. Once it's an ordinance, it goes to planning and zoning. We never see it again. And those are his words. We never see it again. Now, let's talk about what happens next. After that August meeting, within 2 days, because there were 2 attorneys in that meeting, Mr. Strom and Mr. Murphy were both in that meeting representing KBER. Within 3 days, I think it was, at that, Mr. Culberson gets a phone call. I've got problems, this is Mr. Strom, I've got problems with 2 things about that ordinance. Now maybe he said it more nicely than I just attempted to say it, I don't know. But what I do know is shortly thereafter, it's approved, and it looks an awful lot like exactly what the developer wanted it to look like. And it drops to me to a -10 as far as farm friendliness. All of a sudden, private packaged sewer plants, again, my language,
I'll have to agree to disagree with you.
yeah.
We strictly prohibited package treatment plants.
And to me, that's a matter of semantics.
And we'll just have to respectfully disagree. And
Understood.
the court took a lot of consideration into that fact, and then looking at the data and looking at the information provided about what's called the Fuji Clean system, the language that we put in there,
And
we tried to really
Yeah.
put parameters about what went in and the outcomes from the system.
And like respectfully, as far as whatever you're referring to, getting a phone call and making changes, that I don't think is accurate. I mean, we had multiple meetings with multiple open discussions resulting in this thing being amended several times on that particular issue,
And
which is probably why this language here that we're trying to make sure is in the ordinance
Okay.
inadvertently got taken out, quite frankly, because there were so many edits based on all those discussions.
Yeah, so I'll give you, I
but
can give
I
you.
respect your opinion.
Yeah.
and-
I can give you
and-
the email that I'm referring to.
And I appreciate
And please understand, I'm not here, I'm not attacking anyone. I'm
And-
here
and-
as
and I
I'm
don't
here as
feel
a
like
friend of the court, believe me or
No.
not, because I'm not even touched on some of the more pertinent things that I think could make it avoidable amendment. But because I've got some folks over here who want to hire lawyers to start going after this, and I'm like, these are nice people. You know, they're trying to do the right thing, and that's evidenced if you watch those videos, which I have.
I appreciate that.
I'm saying there's no need for saber rattling. Let's walk everybody through what happened. If they're comfortable with it, then we'll have that conversation. But I think if they see it in the light of day, they might have pause to see what happened. So I'll gladly send you the email, Mr. Culbertson, that you forwarded, but that's fine. So now we're up, so we got that sales pitch. There's a document that you have that's a spreadsheet, and I said we'll come back to that April meeting in just a minute, because I think you were working on some misinformation. In the April meeting to Planning and Zoning, there was a statement, there was actually a question about references. And the representative, a lady named Kelly, who was sitting right there, said, and the question was very specific, how many of these are installed in Kentucky? And the answer came back 3. And somebody on Planning and Zoning said, so there's 3 large installations in Kentucky? And the answer, well, they're not actually installed, they're in permitting. And the follow-up question was, well, where are they? One of them, Grider Hill Marina, Albany, Kentucky. One of them, Glendale, which has changed names. I've forgotten what the name of it is now, but it's since been sold in E-Town. And one of them down here in Frankfort at the Elkhorn Creek RV. My history is one of sales, and I had a couple of experiences, actually many experiences, handing out references. And I had 2 rules. One is I never gave somebody a reference where I did not contact that person first, because it's inconvenient and inconsiderate to a customer to just have somebody call up out of the blue asking for a reference. The other one was I always wanted to know what they were going to say if they got the reference. So those were my personal 2 rules taught to me by IBM over years. Something else, I had the pleasure of having some really good managers. One of them always said, Dick, never expect what you don't inspect. So let me ask this question before I say anything else. How many of you, when given, this is a slightly different format of a reference sheet you were given with 29 installations in the U.S., how many of you did the due diligence to check even one of them?
You know, Dick, I can say that I got on the internet and I looked at the lists of
installations that were listed, and then I read reviews. But the big thing that was in my mind was that the state of Kentucky had approved this for use.
You were told that 12 times. I've counted them. And we're getting there. And you're getting ahead of me.
But I have a document as well that
I have that document too.
Yeah.
And I'm going to shoot a hole on it in just a minute.
Well,
okay.
And please know.
I know. And I'm a friend of the court.
Yeah.
You've fallen into a trap, is what I'm trying to suggest to you. Well, following my manager's advice of don't expect what you don't inspect, I've contacted a number of these. First one I called was here in Frankfurt because I've seen it. It's a good operation. I talked with Steve, who's one of the managing directors. No, we don't have a FujiClean system. Never have. They made a presentation to us, but we didn't buy one. We're going to wait for the city to come out.
Well, I can tell you it certainly was presented as.
Peace. I know. That's exactly right. I contacted the one in Elizabethtown now the one in Frankfurt appears on this list that you were given, and verbally it was given to planning and zoning. So neither of those panned out. I called the one in Elizabethtown, same story. We don't have one. We did buy another septic system, but it's not FujiClean. I remember them making a sales pitch to us, but we didn't buy one. So another one on this list falls off. I contacted Grider Hill Marina after more than 2 years. That one is still in permitting, so it's not installed. The list on this says short list of FujiClean USA commercial installments.
So I follow your line.
Okay.
Like what was presented, you feel like
was misrepresented.
Was misrepresented. Let's use that.
Now, I'm not saying someone lied. Please don't hear me say that. What I'm saying is I could easily see where some staff person was given the task, would you go get me a list of installations? And this is the list. And at the time, it might have included some potential sales. So it could have been purely a mistake.
So what I will commit to you is that I will follow up and try to verify more information, since you've brought up a concern, and I hope you would respect that.
Oh,
and I think that's a good path.
Absolutely. No, I think you've got time to do that.
I certainly want you to share your concern about the
state approval.
The state approval.
Yeah. Let's go to that.
And then let's go back and look at the big picture of what we're doing today.
Okay.
The amendment has passed. The amendment
maybe. I've got one more point to make about. So let's not jump ahead yet on that.
But what we're doing today is making sure that the density is in the amendment as it was supposed to be from the start. And that was, you saw it in the summary. We talked about it. It was read in the summary.
Yeah.
It was left out.
I mean, it was passed October 26th of 2023.
Yeah. And it was not in there.
That's what I'm talking about.
Yeah.
So please, what we're doing today is trying to clarify that and make sure it's in there. The next point is that after today's meeting, I can go and collect information and report back to the court, and that's what I will do. And then we can go from there. To this point, and as we have talked many times, there's been no development proposal presented to the court.
That's right.
What we did was for the entire county and an RV ordinance to try to put parameters about what was possible. So if you could share your concerns about the letter, and then then we can ask questions and go from there.
All right, so now let's turn to the letter, the purported state approval. And it absolutely says FujiClean systems are approved. Mr. Livingston brought out a very good point back in one of the September meetings, and he said, you know what, And I'm paraphrasing now, that disaster that we just went through with Spindletop Mobile Home and everything, 40 years ago, that was good technology, but technology changes. And so his point was well taken in that technology changes. Well, the base technology in this FujiClean system is really the same technology that failed over there. So the technology itself gets down to two types of bacteria, aerobic and anaerobic. It just so happens that the FujiClean system combines the two, and it's a really good system. It was originally intended, though, for residential places. If I had to do a septic tank all over for myself, I might choose that system. It's an excellent system. But here's the thing. If you look at this letter that was given to you, there are 3 part numbers on the letter that are approved.
You've had the letter he's talking about is from a gentleman with the.
I don't need it anymore because
and I don't have any documentation here, but this letter is from Scott Samuelson. I believe this is the same letter. It's signed by Chris Edwards, and it's from the Department for Public Health.
And it's also posted prominently on FujiClean's website. But here's the thing, there's 3 part numbers on there. The largest tank is a 1,000 gallon tank, 1,000 gallon per day, I'm sorry. In fact, the tank size is actually 1,200 and something, but 1,000 gallons per day. The same presentation in April as you saw in September does not include any of those part numbers. It includes 4 CE6KG, 6,000 gallon per day tanks. I handed you also an NSF document. So in state statute, it says subcomponents of any sewer system have to be state approved and have to appear on a list. Their list is that list. NSF's list is a bigger list, does not include the part number that you were presented. So now let me back up and say if I was asked, and I was a salesperson for them, is FujiClean system state approved? The answer is yes, absolutely. You have to dig deeper and say, are the components in the system that you're proposing to be used state approved? And the answer would be no.
So let me lean on my planning and zoning staff. I don't want to put you on the spot, but when you get a request for a conceptual plan that's presented, and then when you take that data and share it with the Planning and Zoning Commission, like the specifics of that type of system would be part of your all's consideration, correct? Elise?
Yes.
Could you step over here, Elise? So at the time of a development plan coming to you all of that data comes to you and you all review it.
Correct.
Okay.
Yeah. And then we usually put a condition that they adhere to whatever their related utility provider is. So Georgetown Municipal gets a condition, water companies, sewer treatment, everything like that. Because we understand that they are the experts, but we do consider that when we're reviewing developments. Yes.
So, you know, when we considered the RV text amendment ordinance, that letter, you know, we're not looking at a specific site. We were looking in general at what was presented in that letter, that the FujiClean systems have been approved. Now, what you're presenting certainly merits being looked at and examined closer, and I can assure you that Elise and their staff, as well as us, will look closer and try to get all the information to present to the court after what you're presenting. Okay. So, thank you, Elise.
Of course.
Thanks, Elise. All right, so I'm going to summarize then. I've also handed out a 3-page document that I'll leave you with that basically recounts everything that I've just said, down to my contention.
Is that this document?
Yeah. So it's on the next to last page. I contend the process by which the 2310, which I still consider this to be, now 2409 text amendment, came into being is deficient in several ways. As approved at the October 22 meeting, the proposed text amendment maintained inherent characteristics of A1 zoning. So to me, every time I see agricultural, it's farm-friendly. This one's not. To most of the public, myself included, this version of text was non-threatening to agrarian lifestyle in our part of the county. There was no need to object, no need to be concerned, as the maximum density on property would be no more than 1 RV per 5 acres. There could be no private sewer plants, and prime soil farmland was protected. The public was lulled into a false sense of security. As it appeared, Scott County P&Z had maintained their commitment to keep this part of the county as agriculture, and I would go on to say, and consistent with the comprehensive plan for future land use. Minutes from the, here's one that's real troubling. Minutes from the June 8 meeting, which were approved at the July 13 meeting, do not reflect approval of the text amendment. Rather, just an amendment to the proposed text amendment. After behind-the-scenes discussions, the proposed text amendment morphed into something totally different than originally approved by Scott County Planning and Zoning. Had I been aware of the many changes to the text amendment, I and others would have been in this courtroom as I am now and will be at every subsequent meeting related to this topic. But I was not aware, nor were others, that the agricultural component of A1 had been systematically excised from the RV text amendment. There were no public notifications of planned sales pitches for unwanted private packaged sewer treatment plants, again, my terminology, to P&Z. There was no notification that A1R zoning was to become a back doorway of backdoor way of turning A1 property into mostly highly dense subdivision in the county with their own privileged or their own private packaged sewer plants beside a creek in a karst region. As that's currently written, the 143 acres that we're talking about could house more people than is in all of Stamping Ground. That's pretty doggone dense for our part of the country. Neither the text amendment which came to be known as 2215 nor the text amendment which came to be known as 2310 were presented to the fiscal court with the mandated reasons which supported approval as required by KRS 100.211. In other words, you just got a document that says it's approved, no reasons attached to it. Reasons are a requirement when those are recommended.
So decisions. I shared with you just a couple of days ago that the email from Joe Kane with the attachments, and what you're saying is within those attachments there was no reasoning. Is that what you're saying?
That's right. Or they were not voiced at any of the meetings, the subsequent meetings.
Are you talking about the planning and zoning meetings?
Or the fiscal court meetings, either one. Now, going back to that July 8th approval, let me read the minutes at the very end, and you might want to go back to the video to confirm this. The discussion ended in a very confusing vote, which was recorded in the minutes as, and this is, and I'm quoting exactly the minutes.
And you're talking about the July 8th
That's right.
Planning and Zoning.
The July 8th Planning and Zoning meeting reads as follows. After further discussion, motion by Smith, second by Jesse, to change the number of RV sites to more than 400 sites, requiring a second public road connection, and RV campgrounds with more than 600 sites, requiring a third public road connection, along with the addition of sub-item D, stating that a second access can be constructed as emergency only for the RV camps text amendment public hearing. There's no mention that the text amendment was approved. Now, where the confusion came in is the chairperson was asking for an amendment like that. And then Mr. Perkins, the attorney, interrupts and says, well, and now I'm paraphrasing, something to the effect of, well, this isn't actually a text amendment vote. This is, then he pauses, well, and I'm not sure what it is, but the secretary, but they went on with the vote. And the audio's not real good, so you really can't hear what the actual motion was. But the secretary records it, and then the minutes are approved in the next meeting, absent any mention of the amendment being approved. So I would take the position that you're working with an invalid document because it never really met the measure that was necessary to hand it off or the reason stated in it.
So respect that, and certainly we'll follow up. Cam, I will ask Cam to help with staff and Mr. Perkins to look at your concern.
Okay.
And I appreciate, I appreciate your concern, and I appreciate, you and I have had great dialogue.
We have.
And you're a concerned citizen. And
Then maybe you'll appreciate my request. My request is, rather than a motion to fix the error that occurred, I would entertain, if I were you, a motion to send back to planning and zoning the ordinance so it goes through that proper process.
Well, Mr. Murphy, certainly respect that and certainly understand, but the same thing, we're going through processes, and we will examine the process. I have to do that firsthand with Cam, or I'll ask Cam to do it as county attorney with Charlie Perkins and staff, and then we'll go from there. The amendment or the correction that we're trying to do today, I think, just solidifies what's in there. If it's not valid because what happened at a planning and zone meeting,
then it's not valid.
Then it's not valid.
Understood.
So I'm not disregarding your request. I will certainly commit to you and everyone else that we will follow up and investigate your concerns and try to get to where we're all on one page and go from there. Now, I'm one vote. And if the pleasure of the court is to table this today, that's the pleasure of the court. We don't go on if there's not a motion to accept it. But I certainly don't think that us correcting the issue that we have at task today impacts what you're talking about at all.
Well, let me give you one concern that would impact everybody in this room, I think. In the amendment as it's written, it says I can have 20 acres and call it an RV park. All right, let's say that I am...
But that has to go through them first.
I understand. I'm talking now just about the amendment, just about the amendment. There's nothing in there that says I, as someone who wants to create some cheap apartments, can't say I'm going to build an RV park. But instead of actually inviting people in to stay at my RV park, I'm going to buy, in this case, let's say that it's on a public sewer. I'm going to buy 200 surplus FEMA mobile homes, and I'm going to put them there.
But Mr. Murphy, we have to trust the process, and I go back to the process.
Well, they're not going to say that. If I'm the developer, I'm not going to say that. I'm going to call it an RV park.
Well, the planning and zoning development process, I believe,
would catch that? I don't think it would.
Well,
because it's not in violation of any of the regulations that are in that ordinance. There's nothing.
Doesn't the ordinance say you can only be there
4 months out of a year?
Yeah,
I'm
consecutive.
So, David Livingston?
Well, Ryan just said exactly.
Yeah, it does. It absolutely does. And peace. I mean, I understand. You can only stay there for 4 months. There's a lot of people who would do Airbnb. 4 months, not a problem for them. There's a lot of people who would say...
The intent of 4 months is building itself, not people moving in and out. The RV has to be on.
I understand the intent, but what I'm suggesting is the ordinance does not protect you from the misintent of someone who was in it purely for profit. And if I had 60 acres and I put 3 of them beside each other, there's nothing in the ordinance that says every 4 months I'd like to move you down. Now you got a place cheap for 12 months. Just something to think about. I mean, it's your prerogative whether that's a real concern or not, but there are some people out there who would absolutely take advantage of this as written.
Appreciate your time and respect what you brought today, and certainly know that we will follow up.
I just have one comment. I really appreciate everything you've said, but I know that you said out loud a couple times that you felt this was a backdoor way. I mean, we had 6 public meetings. We posted the agendas. I do a recap every single meeting on it was in the paper. Like, I don't know, I don't think it's fair to say it was a backdoor when we have these, we try to be extremely transparent.
Yeah, I
we do
understand.
everything we can. So I don't think that's a fair statement for this court.
And shame on me. I should have been here a year ago. But now knowing what you know, if it continues to go on, it's shame on you. Now, again, I want to be a friend of the court, but I've told you everything I know about how the ordinance is failing Scott County. Nothing about the RV park that's near me. That'll have its place and time next month. But this is about the inherent flaws of the ordinance itself.
Appreciate it and respect your presentation and your time. Now,
so, Joe Patton, nice seeing you again.
Yes, sir.
I need to say, my name's Mike Hulemar. I live at 122 Creekside Drive. I've been here for almost 40 years now.
Mike,
And
what's your
I'm an
last name?
engineer,
Hulemar.
and I worked for IBM for a number of years. And I've been through this in great detail as a result of this RV park incident. And again, procedurally, and I'm going to address Cam's comments, I think, here. I'm very surprised as an ex-product safety manager worldwide for all the IBM and Lexmark products that came out of that site, that when this was read on June the 8th, and he read the motion, it says in here that a secondary access can be constructed. Not must, but can be constructed. That should be an obvious thing to you all as a regulatory body.
So if I could interrupt you, that was forwarded on June 8th to us, and then I don't have the text of the whole thing in front of me, but it says shall now, I believe.
Yeah, that was another point of discussion at those multiple meetings we had, and I remember that. Those were the
Well,
two
it
things.
came up, it came up
And that
in
was
great
Mr.
detail.
Livingston, and as Dick pointed out, like, that was a point of conversation and concern, and then much conversation with Chief Ward about access for first responders, but please continue.
We're on the same page
Yes.
in the sense that you got EMS, you should somebody from the fire chief, you should have police chief, all of those folks. You've got essentially a 2-mile almost island there with one access point over a 200-mile bridge.
But I go back.
You've got to have
There's
secondary.
never been a proposal presented to this body. We have operated only in a blanket of this RV text amendment. When the process goes to a development proposal, there's a technical review committee, correct? And that's when your technical review committee goes through the very details of fire protection, water flow, access, all of that. So, like, this body has never heard any development plan because it's never been forwarded. And we had to operate looking at a holistic approach for the whole county. Sadieville, Stamping Ground, the whole county. So when you get to the process point for planning and zoning, the technical review committee, that is the point when those experts sit down together and look at the proposal and the concept plan. And I would invite Elise and Red or any of you all, am I correct? If you would.
Yeah, I'm getting back up. I got to do that.
Get your steps in.
Honestly, it's good. I get them early. Otherwise, I won't get them later. Yeah, that's correct. When we have any zone change request, any subdivision plat, any development plan review, everything has to go through technical review. And we send out a list to our list of over 20 individuals of various agencies, utilities, and providers to receive their public comment. And they submit it to us. We talk about it at the meeting themselves if they're present, or they send it to us later, and we send a document out to every point of contact on our development plan application form saying, this is the comments that we received. This is the discussion we had. And then they are expected to adhere to that. And then if they get past that point in a development plan subdivision plat, for it to be recorded and be potentially taken to the actual execution phase, they need to take it to various utility providers and service providers to receive their signature, essentially saying that this meets our requirements and it satisfies all of our things. And it goes forward to actually talking about actually happening. But there's multiple checkpoints along our process way to make sure that we have these open lines of communication with experts in their field. So we're not misconstruing things, and they know as soon as the technical review what's expected of them.
So along those lines, we're, I'll invite you, Mr. Hunemeyer, to come back to the, along those lines, the court has not had any presentation for any specific development plan or recommendation from them. So please know that that is forthcoming as we move forward.
Well, let me ask this specifically then, now that I've heard what Elise just said. When there was an over 500% increase in the density of this from what was 1 to 1.735 to 5 to 1, 5 RVs for 1 acre, who approved that in the TRC meeting?
There's
The reason why I asked that question, because if you read the transcript from the meeting on June the 8th, or I'm sorry, May, when Matt Summers stands up, and I've got the copy of it here, he says that it was changed in discussions with Mr. Richard Murphy and the developer. I would like to see the subsequent engineering data that actually allows, because I can't find any, for you to go from a 1 unit per 1 3/4 acres to a 5 units on 1 acre, which is over a 500% increase in the density of this. I'd like to see the engineering data, because Matt Summers says between April and the May meeting that he has met with Richard Murphy and the developer and decided to change it to 5 to 1.
I can't answer that, but
I'm asking that to the court. It's another point of
Elise,
due. I'd like to see the engineering data.
I'll ask Elise and her staff to give us feedback on what that number was based on. It has to be on some number. That's a frame of reference for that number. And Elise, I'm not going to put you on the spot. If you can get that back to us, that'd be great.
Yeah, I can do something like that. I would like to point, as you stated before, that this is for the overarching undeveloped areas of Scott County. So if a developer comes in and wants different things, they can request it based off their ordinances. The 5 units per 1 acre is when you are on public sanitary sewer. The 1 unit per 1.75 acres is when you are on a approved private system, I believe, if my knowledge is correct.
Oh, it's 10 when on public.
10 per gross acre on public.
Thank you. And then the 1
5 per gross acre on private.
Yes, and we can look into that one and go further with that. I apologize on the misunderstanding of where we were on that one, just with all the numbers we've been running around with. But I can see what I can find with that one. I'm clearly not Matt, so I will do what I can to become Matt and get that for everybody.
If you can share that,
yes,
that'd
I'll
be great.
see what we can find. Yes, sir.
Mr. Hulemeyer.
One last thing. This is an article that was written in the News Graphic on October the 6th. It's talking about the quote, public-private sanitary sewer system, okay? And it's from Mike over there, the editor, and he says, and I'll read it to you because it's not very long. It says, allowing private sanitary plants is a bad public policy. Scott County Fiscal Court ordinance regulation RV parks that includes allowing a private sanitary sewer system is bad public policy. Fiscal Court held her first reading last week with only Magistrate Chad Wallace dissenting. We must only look at the Scott County, Fayette County line and the failing sanitary systems at several mobile home parks to see why this is such an ominous step. For years, the two plants have served these mobile parks, disputes rear sewage and nearby creek and waterways, not to mention reports of raw sewage seeping into the ground near where children played. It was regarded by many as one of the state's greatest environmental hazards.
And Mr. Heulemeyer, appreciate you sharing that.
I've got this, it's in the record. I want it to be in the record.
Well, you're on the record.
I understand.
So certainly respect that and certainly respect the editorial comments, but the fiscal court, using the data that we presented and the information that we presented, and then putting in additional, what was at the county line at the Lyle Road Trailer Park was a failed package treatment plant, and no questions asked, and it was a big negative impact. But what we put in our text amendment, there were additional language, and we prohibited package treatment plants specifically, and no questions. What's being presented with the
so how do you
system.
I'm sorry, how do you differentiate private from package? I'm having a really hard time with those definitions of those.
A private system, there's a variety of different private systems. There's just septic tanks, there's package treatment plants, and then there's and there's others, but what's been presented as a potential use out there is the Fuji Clean system.
I understand.
And based on the information that I received in the letter that it's going to be approved by the state, or it had been approved by the state, let me better well said, that's why we included that. And it's a holistic, overarching ordinance to cover the whole county. And there's also other safety measures put in there about inspections and such. To say that we didn't consider and is not, it's not accurate in my mind. We put other items in the text amendment to protect our community. And
I read all the caveats.
Well,
I've read them all.
Yeah.
It's basically report, and I think it's reports by the owners. That's kind of like the fox watching the hen house, Joe Pat. I'm sorry, but I don't agree with those. Those caveats were there because you wanted to protect yourself in a private sanitary sewer system, so to speak.
Well,
and I've seen enough.
I'll stand, we can agree to disagree, and we've listened to you, but, I look myself in the mirror every day, and I get up, and I serve my community. Mm-hmm. And you and I might have to agree to disagree, but what we did collectively, we put additional measures in that ordinance other than we do not allow package treatment plants. They're prohibited. That was what happened. That was the system in place at the trailer park on Lyle Road. We have prohibited that, and we put additional language in to guide what could be used and not. And then when we go to a plan development, the technical review committee and the planning and zoning will review exactly what is presented, and then they'll make a recommendation. There'll be a staff recommendation. Then the planning commission gets to review it. What Dick has asked us to do is go back and really drill down and look at, hey, was what was presented accurate? And I've pledged to do that today.
Okay.
So I'm gonna move on from this. I appreciate your time, and I'm gonna ask the court, what's the pleasure of the court?
Can I just say that I would contend that the system you looked at, by definition of the comprehensive plan that was in place when you voted for it, it's by definition a packaged sewer treatment plant, because the comprehensive plan very clearly says packaged treatment plant is, it's a statute that says, that's 2017 ordinance actually, it says packaged treatment plant is a private, installed by developer sewer system. That's it. That's all it says.
And Dick, you and I think you and I have talked about this. What's presented to me in the research that I've looked at, the Fuji Clean system is classified as a drip irrigation system.
No, that's
that's
separate.
And I've pledged to you that we'll go back and look and try to fact check
They do plan to use for the effluent a drip irrigation system, but that's totally separate from the actual processing of the waste.
Okay. So with all that's been said, what is before you, and we've had a second reading, are there any additional comments? And, what would the court like to do?
I feel like you need to read it because it's a correction. So you're going to be, you're going to have an error.
We've read it.
Cam read it.
I mean, vote on it.
You mean vote on it?
Oh,
Yeah.
no.
Sorry.
Yeah, but I'm asking the court for their pleasure.
Yeah, I'll make a motion just because this is what we originally voted on, so that the language is in there, and then also because currently right now, if an RV park was to submit an application to P&Z, they could really put as many as they wanted to on a private system because there's no regulation at all.
And I can't disagree with you.
So for now, I will make the motion.
I'll agree with you, Ryan.
As Cam said, 24.
I think this actually helps what we want, which is to have more things in place for what we're voting on today. Now, I love the presentation, and I hope everything gets looked at. But I think what we're doing today actually enhances what we're all after, which is to try to help on this density question.
Well,
so I'll make a second.
And on that, Dick, I commit, as I've said, to drill down, and I might even ask you to come back and meet with us, just so we make sure that we're looking exactly at your concerns. And so we have a motion and we have a second. Any other questions or comments?
I have a comment. When we started down this path, what we had in place for RVs needed to be changed. There's no doubt about that. But I'm not happy with the way we changed it, and you all know this, that my contentions with this RV, or the RV ordinance. But I do believe, Judge, that if there is information in our research that is found that has to do with the Fuji Clean system, then we need to come back and we need to revise this ordinance based on your pledge to Mr. Murphy to find out if there's things that were said that were not approved by the state. We'll need to come back and we'll have to address this again. But I believe that's important.
I've pledged to do that, and we shall do that. And if there's information that's contradictory and there's not accurate, then that's the time to bring it back to you and let you all consider what is before you at that time. But we made decisions based on what was presented at the time, and I stand by the process. And if there's information that's not accurate, then let's go back and let's talk about it and let's do what's right. I think this court has a history of doing what's right. You look down on Double Culvert Road. I think everybody goes to bed thinking what was done when we amended the solid waste management plan. That was done right. When we did a solar farm ordinance, that was what was right for our community. When we did a transfer station ordinance, that was what was right for our community. So we have a history of doing what's right, and we'll continue to do that. I've lived here. I love this community, and just like you all, and we're going to do what's right. So we have a motion and we have a second. Any other questions or comments?
Joe?
David Livingston.
Yeah, number one, if it's too loud in there, ask our friend to turn it down.
Okay.
I don't control the volume that you're in. So I agree exactly with what you said about the process. And I think it's something I have to look at as far as the ordinance. But I also wanted to ask if that document that David emailed to me.
Yes. No, we'll scan it, and Stacy, after this meeting, David, we'll scan what Dick gave to us to get in your hands.
Thank you.
Yes, sir. So we have a motion, we have a second. Any other question or comment? All those in favor, please say aye. Aye. Any opposed?
Aye. Or nay?
Hold up. Rick gave me a finger in the middle of it. So I'm going to...
Not the finger. Not the finger. Well, kind of agree with all sides, and I think I made the motion the last time, if my memory's correct. And that was my goal, is what Ryan and several have already stated. We had kind of an open-ended thing where anything could happen, and I was looking for something to at least put some guideline, X amount on X. After this discussion, which is what should happen in my memory and in my view in the future, when a particular developer comes, it sounds like there's one getting ready to come, but I've also heard there were people looking in the northern part of the county. I stated this last time we looked at this. I wanted guidelines even before those folks. I'm not sure if they're coming or not. I don't know. But they were looking around in the northern part of the county to do a very similar thing, very close to an interstate exit. And so I wanted guidelines more than that open-ended. So that anyhow, I just kind of wanted to restate that. But these folks have presented some very legitimate, and yes, in fact, back to Mr. Murphy's statement early on, I think, Judge, you and I were sitting at your computer researching some of this stuff that was presented to us back then. I mean, I feel like the other guys looked at this stuff too, but you and I looked at them together. We were trying to decide, is this Fuji Clean, what's it all about? Obviously, we if somebody comes forward, however this plays out, that's got to be looked into deeper. And because I've worked on sewage treatment plants, I know what a packaged sewage treatment plant is. Or I'm not an authority, okay, but my idea of that, and the Fuji Clean is a package. It's a treatment opportunity. It treats it. I've never been around that, but what I'm saying is that the Lyle Road problem is, I don't even think the state will. I thought in some of our research, and we're looking at that, the state probably would never approve something.
From my
like
understanding,
and again, I don't think we got that in writing or anything, but I thought we looked around on that, and that for sure is a packaged treatment plant. It's exposed, and it's always got effluent going out to a nearby creek, or it creates a creek, actually, if there's none around. So anyhow, that's what I was looking for with this ordinance, is to get some kind of guidelines instead of having it so open-ended where somebody could come and we'd be in a real dogfight possibly. Anyhow,
yeah.
That's what I wanted to
So
cover.
I just want to go back. We had a motion and we had a second. I called the question. I believe it was 7-1. I mean 6-1. Is that correct?
I think so.
So I just wanted to make sure we were all on one page, that was clear as clear could be, that amendment passed and will be in the text amendment moving forward. And I'm like Kelly and Ryan. I think it protects us. Now, as we gather more data and follow through with my pledge to Mr. Murphy and Mr. Hunelauer, as we go gather more data, we'll bring that information back to this body and certainly share that information. So with that said, we'll go on to number 9, ordinance 2407, second reading, LGEA budget amendment.
Ordinance 24-07, Scott County Fiscal Court, an ordinance related to the annual budget and amendment thereof, whereas Scott County, Kentucky has realized unbudgeted receipts. Be it ordained by Scott County of the Commonwealth of Kentucky, Section 1, current fiscal year 2024-2025. The budget for the current fiscal year is amended to increase/decrease the receipts of the following funds to include unbudgeted receipts from A, revenues, LGEA fund, surplus prior year in the amount of $50,000, so the total amended revenues is $50,000, and appropriations, LGEA fund, LGEA fire special projects, amount of $50,000, total amended expenditures is $50,000. Section 2, the amounts adjusting the receipt and expenditure accounts in Section 1 are for governmental purposes. The first reading was done on August 22nd of 2024, and if you approve it, that'd be today, September the 13th, 2024.
Any questions or comments? Would there be a motion to accept? Motion. Second, Mr. Hosteller. Any other questions? All those in favor, please say aye. Aye. Any opposed? Motion passes. That leads us to 2409, first reading. I'm sorry, 2408, first reading. And would there be any comment from planning and zoning or from the applicant prior to consideration of the court? I'll ask Cam to read the summary first, and then if there's any comment by planning and zoning or the applicant or any individual in the audience, be happy to do that before consideration by the court.
All right, Scott County Fiscal Court Ordinance number 24-08, an ordinance relating to changing the zone for 0.95 acres more or less owned by Country Boy Holdings LLC, said property situated at 6325 Cincinnati Pike in Scott County, Kentucky, from B2 Highway Commercial to B5 General Commercial Park. Whereas the application of Country Boy Brewing having been filed with the Georgetown Scott County Planning Commission on June 28, 2024, requesting a zoning classification change from B2 Highway Commercial to B5 General Commercial Park for 0.95 acres more or less, situated at 6325 Cincinnati Pike in Scott County, Kentucky. And whereas the matter having been heard publicly by the Planning Commission on August 8, 2024, pursuant to notice according to law and with a quorum of the Commission present and voting, and whereas after taking testimony on the application and fully considering same, the Planning Commission voted unanimously 6-0 to recommend approval of the rezoning request, and whereas the Scott County Fiscal Court, after fully considering the application, record, and recommendation of the Planning Commission, hereby accepts the Planning Commission's recommendation and grants the requested zoning classification change for the subject property from B2 Highway Commercial to B5 General Commercial Park. Now therefore be it ordained by the Scott County Fiscal Court, Section 1, that the Georgetown Scott County zoning ordinance be amended to show a change in the zoning classification for 0.95 acres more or less situated at 6325 Cincinnati Pike in Scott County, Kentucky, as described in the application, for the property of Country Boy Holdings LLC from B2 Highway Commercial to B5 General Commercial Park, all in accordance with the application for same, said property being, I'm not going to read this particular legal description, but there's a legal description that can be found Deed Book page 450, Deed Book 450, page 767 in the Scott County Clerk's Office, Scott County, Kentucky. Section 2, that the Georgetown Scott County Planning Commission is hereby directed to show the zoning classification change on the official zone map and refer to the number of this ordinance. The first reading was approved, is today, September 13th, 2024.
Thank you. Any questions or comments from the court? Any questions or comments from planning staff or applicant?
Ms. Hamilton, Judge, gentlemen, I don't have any immediate comments unless you all would like me to rehash any of the conversation we had in workshop, or if any members of the community would like me to do so. The applicants and their counsel are here as well. So,
and you know, we did have a workshop, and we did talk about the request at hand.
Yes.
So,
I have one question. It might be, excuse me, for the applicant, but maybe you can answer it, Rhett. So, listening to that to the workshop meeting, there was a question about hooking onto the sewer. The sewer's at capacity. If capacity changes, would the applicant then? I know they have a septic currently, but they would then. Are they mandated, or they have will have the opportunity to hook onto the sewer?
There is no mandate with this current rezoning. It's not uncommon or customary if a rezoning occurs adjacent and adjoining to an existing city limits, that may become a stipulation of approval. They're still well south of Sadieville city limits, sure, which is essentially up there at the interstate exit and slightly up Porter Road as well. As far as their intentions for future attachment to sanitary sewer, I won't put words in their mouth. I'll let them speak to it if you'd like to hear from it. but it's been illustrated that their current proposed use would be sufficient for their private septic use. However, and this is a great time to illustrate this, we are currently only in the zone change process to consider the use and future use of this property. Once we get to, assuming that these gentlemen bring a development plan, at that point, the use of that septic for their proposed use will not only be evaluated by us, but also the county health department as well. And also in conjunction, again, we touched on a TRC committee meeting. There will also be representatives of Georgetown Water and Sewer there as well, who will be able to provide further guidance at such time of what the proposed capacity and opportunities may be moving forward. Again, just a zone change here, those steps occur assuming they get continued approvals and that they do bring a development plan. Those steps will take place at that time. But to recap, no, there is no current mandate.
Okay. So then I'll ask the applicant, is that what your all's intention is to eventually, I think I know the answer, but I want to hear it from you all.
Yes, Magistrate Wallace, John Woodall on behalf of the applicant. That's absolutely the intent.
Okay.
We can do that.
Yeah, once capacity is available.
Yes.
Yeah.
Any other questions?
We'll go for it.
Along that same, thank the chair for bringing that up. I think I was the one that brought it up in the workshop.
Yeah, I think you were.
Along that line, and I appreciate, Rhett, if you don't mind, your presentation at our workshop and a lot of good information. But along that same line, so there is a process where they will assess that existing septic, because I know it was a slaughterhouse, so I'm sure they handled a lot of fluids.
Yes.
I'm sure that was happening, and I know that thing's been there for decades, but that's still going to be assessed.
Yes, sir. Again,
make
just
sure
to,
it can handle whatever their proposal.
Yes, not only the proposed use and function of the property itself, of course, if they're going to entertain any sort of public functions, which again, development plan process, health department and or Georgetown Water Sewer will review the plan and say, hey, you have X number of fixtures and bathrooms, et cetera. Will we be able to, what are your hours of operation, your expected capacity? There's a lot of algebra that does go into it, but as of yet, still at the zone change as far as potential use, not only for these folks or anybody else. I hope they're successful and they carry through with their process, assuming they receive continued approval. But the reality of it is with a zone change is that these folks or anybody else can receive a zone change, things don't work out, the next day they sell it. So just to, circle back and rein us in a little bit, we're just at the zone change here, looking at proposed use and potential future use. But yes, there are multiple still checkpoints along those lines for this proposal and any.
Any other questions?
Motion for approval.
Motion by Mr. Ryan Pratt.
Second.
Second by Mr. David Livingston. Any other questions or comments? All those in favor, please say aye. Aye. Any opposed? Motion passes. Thank you all. That moves down to 11. Ordinance 2409, first reading amendment to the short-term rentals. We've talked about this quite a bit. I talked to Lori Saunders yesterday. Lori was sending an email out. She has a listserv for short-term rental folks in the county to let them know that we were having a first reading today, and the proposal is to simply change the wording in the ordinance, and it stipulates that there would be a maximum of 2 adults per bedroom plus 2 adults at a short-term rental. And I sent an email out about that yesterday again, and I would ask for any questions or comments. Then I would ask Cam to read the document, and then we'll have any other questions at that time as well.
Okay. Scott County Fiscal Court, ordinance number 24-09, an ordinance amending ordinance 22-08 regarding short-term rentals within Scott County. Whereas the Scott County Fiscal Court desires to amend ordinance 22-08 regarding short-term rentals in order to enact further regulations that discourage improper conduct and promote the safety and well-being of the community. Now therefore be it ordained by the Scott County Fiscal Court, Section 1, Ordinance 22-08, Section 1, 7, duties of a host is amended as follows. 7, duties of a host. E, short-term rental occupancy is limited to 2 adults per bedroom plus no more than 2 additional adults. Section 2, all ordinances or parts of ordinances in conflict with this ordinance are hereby repealed. Section 3, this ordinance shall be in full force and effect upon passage and publication, and publicly introduced and read the first time September 13th, 2024.
Questions or comments?
I'll make a comment really quick. I appreciate the work and everybody looking at this. It's not been easy, and there's a lot of things that come up, but we've had people in my community and I guess my district that have brought up their concerns, and they've been appreciative of us looking at this, and I'd make a motion that we approve it.
We have a motion. We got a second from Mr. Ellison. Any other? Yes, sir.
Just
any other questions, Rick?
Yeah, not really a question, but a comment. This is another kind of an example where we had one issue in one property that even the sheriff's department had to get involved. The numbers were crazy. The folks that were attending there. So this is another way that to at least give the sheriff's department or local police department, if it's in the city limits, if something of this nature happens, at least they've got something on paper to say, hey, you guys are way over capacity, because they were way over capacity in the one incident that happened, but we really didn't have numbers. So they couldn't really look at them and say you're way over capacity because wasn't any. But now we do. It's just another example of you can't catch everything. So when something happens, we're trying to fix that.
No, appreciate it. Any other questions or comments? You got to call the question then. All those in favor, please say aye. Aye. Any opposed? Motion passes. Presented to you a facilities usage agreement renewal with Parks and Recreation and the Scott County Board of Education. And are there any questions as that is presented in that agreement? It's the standard agreement that we've used. It's just renewal, pretty much.
You need a motion?
Motion from Mr. Hostetler.
I'll second.
Second, Mr. Jones. Any other questions or comments? All those in favor, please say aye. Aye. Any opposed? We'll get that to Mr. D.T. Wells today. Resolution 2422, Attorney's Office Private Practice Policy. It's a resolution. It's been shared. We've had discussion at the last workshop about this. Cam, would you read the resolution?
Yes, sir. Scott County Fiscal Court Resolution number 24-22, a resolution of the Scott County Fiscal Court or Scott County adopting a private practice reimbursement policy for the Scott County Attorney's Office. Whereas Scott County expects the Scott County Attorney and all assistant Scott County attorneys to conduct themselves and office business in a manner that reflects the highest standards of ethical conduct, which will put their duty to Scott County and the Commonwealth of Kentucky first and foremost. And whereas county attorneys and assistant county attorneys shall not be prohibited from the private practice of law pursuant to KRS 15.765 and KRS 15.770, and whereas a policy is needed to establish a reimbursement formula to the Scott County for a county attorney's or assistant county attorney's occasional use of his or her office for private practice. Now therefore be it resolved this 13th day of September 2024 by the Scott County Fiscal Court. The Scott County Fiscal Court hereby adopts in its entirety the Scott County Attorney's Office Private Practice Reimbursement Policy attached hereto and incorporated fully by reference. Done this 13th day of September 2024.
As we discussed in the workshop, this number is based on qualified professional appraisers' data, and that's what gives me, gives me the support for this document. And I think it's good to have a document that outlines this topic. So with that said, is there any other questions or comments?
I just say I appreciate Cam bringing this and following through on it. I know it was a point of contention in May, so
thank you.
Kudos to you and trying to do the right thing.
Thank you, Ryan.
Appreciate that, Ryan.
Thank you. Is that a motion?
Oh, motion, and a motion.
Motion, second, Dwayne. Any other questions or comments? All those in favor, please say aye. Aye. Any opposed? Motion passes. Number 14, as I shared earlier, I need to get I need another piece of data before we bring the EMS, the new EMS station, security cameras and access control proposal to you all. So we'll put that on the next agenda. And then number 15, as I shared in an email, this is about opioid settlement funds. Last year, we agreed to fund up to 2 school social workers at $60,000, up to $60,000 each, to work with young people whose families are being impacted by addiction, or that student might be impacted by addiction themselves. As I shared last year with the late hire date, we only expended approximately $53,000, I think it was. And what I'm asking you all to do is approve, and I'm recommending to approve one more year to fund the 2 school social workers up to $60,000 each. And after this, Superintendent Billy Parker has shared with me he intends to fund this through school funds after this year. So that was a question I had before the meeting, and I just wanted everybody to have the same information. Questions or comments? And I've also asked, like, we're going to have a presentation, have these social workers visit and kind of share what's going on. If Dwayne would help me navigate that, that would be good too.
Is this general fund or is this
opioid settlement funds? And to date, we have, I think, been allocated $591,000. We're using these funds for this. We're using these funds to fund part of our community paramedicine position, and then we're also using the funds with the NET device. So, motion from Rick Hostetler. Second from Mr. Jones. Any other questions or comments? All those in favor, please say aye. Aye. Any opposed? Motion passes. New business. I'd just like to ask Zach with Studio 46 to put up a couple pictures that I had shared before our meeting, if he would. There's your EMS station from the back on the other side of Lexus Way. It's moving along very well. Very, very pleased with the progress there. And then there's another picture, I think, of the farmer's market. They have stood up metal, they've stood up steel, and are working on that today. We have a meeting here in just a minute to follow up on that. But I'm very, optimistic that once this gets going up, it's going to go up pretty well, and very, very pleased. I think it's going to be a fantastic facility. I was by the sheriff's office yesterday with JR, and like they are making real headway on the steel and I think the roof. I don't know if the roofers have actually started, but they're not far from starting. Is that right, Ian?
They've mobilized and started.
Okay, they've mobilized and started. So the sheriff's office is moving in the right direction. Very pleased and happy with that. And then our Justice Center project, they're moving dirt, and on Monday, it's my understanding that they're going to be starting on the sanitary, and there's a lot of work that has to be done there before you can actually get into digging the foundation and such. On the Washington Street side, there's a shoring wall that has to go up because of the amount of infrastructure that needs to go along those pipes with the utilities. So I just wanted to share that those things are moving. Any other new business from the court?
I just have a question. With the sheriff's office being so delayed, Rick and Rob might have to help me. We paid to expedite some piece of electrical equipment. I don't know what it was called.
It was called a switch gear.
That thing. Is there anything we can do to we paid extra because we thought it was going to be done, and now it's not going to be done. We could have just had it arrive without paying all that extra money. Is there any recourse we have? It might be a question for Cam.
And Ian is here, and he might have to get back with us, but we'll try to get that answer to you.
Well, the delivery date would have delayed the installation of the electric and roughing is going on in the basement right now. So it would have delayed, continued to delay.
So it still helped us. So I'm sorry, so it still helped us?
Yes, it didn't help with the grand impact we were looking for, but it did still give them something that they could keep moving and allow that electrical work to go on.
And plus, Ron, Rick might have the same experience. We get dates all the time. Most of the time they're not met. So I think it did help out getting us what we needed.
Thank you, Rob, and thank you, Ryan. Good, I appreciate Chad Wallace.
This is another question for Ian, but wearing a different hat. So you're a constable, if not anybody knows that. You still serve papers, correct?
Yep.
And Dave Willis, who has been a part of that deal, fell ill. And so I had a lady down at the circuit court office contact me and said, they're overwhelming you with getting papers served and, whatever that is. Is there somebody else that can help get papers served and you may, that's their words to me. You might be completely fine in handling the workload, but it does seem like that maybe you've got a lot to deal with and you could speak to that as a constable.
Mr. Wallace, obviously, I have a day job.
Yeah.
So I think that impacts a lot of Dave being retired, deputy.
Yeah.
That left his day open, and everybody that's kind of done that for the landlords here has been a retired law enforcement officer that is available during the day.
There's another one that comes in monthly and brings me a report. He's serving some papers.
These guys can get it too.
There's always the sheriff's department.
Yeah. Okay, so the SO can do that as well.
Absolutely.
Okay.
And the SOs, I think's got a little more rigid scheduling to get convictions and things scheduled. I can't really speak to that, but I think, we're getting it done.
Okay.
I think the eviction side is what's going to get them concerned because the majority of them, evenings and weekends, and, they want their staff to do it during the day because they have to hire people that move a lot of these, so that's, I think, where the heartburn.
You're talking about like for the set outs?
Yes.
Yeah.
Yeah, any of the forcibles and any of the general paperwork can be done at any hour of the day.
Okay.
I'm getting that taken care of for Dave, but scheduling their set outs, again, can't speak for the sheriff, but I think they have some stringent dates that has to occur on where the retired deputies as constables have an open schedule and make that a little bit more convenient for them, which I don't have that schedule to carry that on for them.
It sounds like you're all making it work. I didn't want it to be an issue, become an issue, go long term.
Again, there's always the sheriff's department.
Okay, thank you.
The KRS revision for the constable's authority, I think, has complicated some of it as well. And then there's still 7, but only 2 of us basically work. And Stacy said another one is doing a few things. So.
Yep. All right, thank you. That's it, Judge.
Thank you. Any other new business from anyone in our audience? With that said, then, would there be a motion? Motion to adjourn.
I'll make it.
Motion, is there a second? Second from Mr. Jones. All those in favor, please say aye. Mr. Murphy.
Hey.